Earlier this week, a New York judge made a determination that some are calling a corporate death penalty and a serious blow to the existence of the Trump organization as a whole. Specifically, Judge Arthur Engoron determined that former President Trump and his co-defendants are liable for fraud through the Trump organization. As a result, the Trump organization appears to be positioned for dissolution in New York. Admittedly, that does seem like a lot of power for a judge to have. The question is it warranted? And another thing is that this order came ahead of the trial, which is scheduled for October 2nd. So close to Mean Girls Day.
It's October 3rd.
Anyway, there is a lot of Trump litigation out there, so it's understandable if you don't know which case this is. So in this video, we're going to get into what this case is about, what the judge actually ordered, and how a determination like this could even be made ahead of trial. Let's get into it. Okay, so let me start off by saying that if you are new here, my name is Alita. I am a lawyer licensed in California and DC, and this is not a political channel. We talk about the law here. I don't really like getting into politics, although there are inevitably some touch points between politics and law. Where that happens, I prefer to talk about the law and leave the politics to the pundits to do what they do best. So if punditry is what you're looking for, this is your fair warning that this is not a video where I am going to be celebrating or condemning this decision. Okay, with all of that said, let's talk about this because this appears to be kind of a big deal even outside of the world of politics. Basically, a major organization has just been told by a judge that it's getting dissolved because of its behavior. Whether you're happy or angry about this decision, you probably recognize that this is kind of a big deal.
I'm kind of a big deal.
There apparently has only been one other time that the New York Attorney General has tried to give a business the corporate death penalty. That was reportedly the National Rifle Association, the NRA, but there the NRA won. And as it tends to happen with Donald Trump, we are in some unprecedented territory here. Okay, enough vagaries. What does corporate death penalty even mean? It's what we call a judicial dissolution. It's similar to when a company goes bankrupt or a sole business owner dies without some sort of a plan for what to do with the business after they die. A judge appoints a third party to determine where the corporate assets go, starting of course with the liabilities, the debts of the company. But specifically in the case of a corporate death penalty, the dissolution happens because the judge determines that the business has been behaving in a way that is outside of what's allowed by the law. In this specific case, the judge determined in a 35-page order on a motion for summary judgment that Donald Trump and his co-defendants are liable for fraud through the Trump organization. Now, let's take a step back for a clearer picture on what all of this means. To do that, we're going to talk about the lawsuit as a whole for a moment. Sometime within the last couple years, New York Attorney General Letitia James filed a lawsuit against Donald Trump and a bunch of co-defendants for 7 causes of action. They're all slightly different, but they all involve some kind of allegation of fraud. And more specifically, we are talking about documents that represented the size and the value of Trump's businesses that the defendant provided to banks and insurance companies. According to the lawsuit, the Attorney General alleges that the defendants misrepresented the size by inflating the valuation of the businesses so they could unfairly get better deals with banks and insurance companies. And when I say misrepresented, I mean they are alleging that they were off by like hundreds of millions of dollars. And so one of the core arguments in this case is how a business can properly value its assets. Understandably, when you get to high finance, businesses that are moving around hundreds of millions or maybe even billions of dollars, it can be tough sometimes to estimate how much things are worth because they are just so out there from the normal markets. Trump's legal team has argued that the valuation of a business like this one is much more subjective and fluid and nuanced than what the Attorney General would like to think. But in this most recent order, the judge pointed to New York case law that actually says the opposite, that an objective analysis of how much properties and other assets are worth is not only possible, but that that's the way they're supposed to be valued. And when I say objective analysis, what I'm referring to is, for example, when a real estate owner gets a third-party appraiser to inspect the property and give an analysis and an estimate of how much the property is worth based on the size, the maintenance of the property, the neighboring lands, and any restrictions that might be on that property. The court basically says that the proper way of determining Trump's property values is essentially the same as what anyone else would do when they're buying or selling a home. But even aside from that particular argument, the judge says that this case really boils down to a documents case. In other words, the judge said that this case is basically just comparing two different sets of documents. The documents that the Trump organization gave to some people like banks and insurance companies, and then comparing those to the documents that they had maybe internally or that they had received from these third-party appraisers who had otherwise analyzed the valuation of the same properties. In other words, the most central question here is, was the Trump organization over here saying that their business valuation was super, super high so that they could get better deals on loans and on insurance packages, while at the same time knowing that someone else has entirely valued their properties at a much, much lower value? For example, there's Trump's Seven Springs estate in Westchester County, New York. According to this most recent order, over the years, these properties have been appraised by various third parties. In these appraisals, they've been estimated to be worth around $25 to $30 million and at most $56.6 million. Despite that, the evidence that's been shared between the parties apparently includes evidence that shows that the defendants reported to banks and insurance companies that the value of this property wasn't 25 to 30 or even 56.6 million, but around 261 million to 291 million dollars. That's kind of a huge difference, I'm not going to lie. But that's just one example of the kinds of arguments going on in this case. But all this talk about fraud and misstating documents has me thinking about the fact that there are in fact forces out there looking to use financial and personal information for all the wrong reasons. As an example, I remember being mildly terrified when I learned about the existence of data brokers that buy and sell our personal information like commodities. You probably know what I mean. You go and buy a gift for someone's baby shower, for example, and then all of a sudden all of your advertisements have to do with like diapers and pacifiers. Or maybe you've noticed that you're getting more strange phone calls from numbers that you don't recognize and might be from like all over the world. It's an absolute epidemic. And that's why I'm so happy that this video is sponsored by an awesome brand like Incogni. Incogni is a data privacy protection company that scans the internet for your information to get it removed from these deep, dark data brokers for you. And if you go to incogni.com/legalbytes, you'll get a whopping 60% off. With Incogni, you don't have to investigate how deep the rabbit hole goes. All you have to do is sign up and they do everything for you. It's such a relief. They start by scanning the internet for your information. This includes stuff like your full name, your email address, your home address, your relatives, employment history, even your social security number. Then Incogni immediately gets to work to get your information removed from all of these databases. Some of these get removed literally in minutes. I had something like 20 immediately removed when I first signed up. And I have to say that instant response was so satisfying. Anyway, then they get to work dealing with some of the trickier data brokers, the ones who really want to give you a hard time before they remove your data from their databases. Incogni handles the back and forth with these data brokers to eventually grind them down to remove your information. At this point, using Incogni services, I have now had my information removed from 40 data brokers. That is amazing. Of course, technically, I could do all of this myself if I decided to figure out where all of the data brokers are that have my information, look up the right language to use for these correspondences to get that removed, sit down and draft all of those correspondences, argue back and forth with the trickier data brokers. But that's a huge headache that I just don't have the time or the patience for. And considering how much time all of that actually would cost me to do all of that myself, it is so worth the cost of Incogni services. So if you want the internet cleared of your personal information, go to incogni.com/legalbytes and enter the code Legalbytes for 60% off an annual plan. The link is in the description below, and be sure to remember to use the code Legalbytes for your sweet 60% off. And thanks again to Incogni for sponsoring this video. Okay, so then how did this decision come about before this even got to trial? More recently, the plaintiff and the defendants all filed competing motions for summary judgment, or MSJs for short. This is a specific kind of motion that is intended to narrow the scope of issues that actually make it to trial. This is done by looking at some or maybe all of the claims in the case and determining where the facts show that the issue is totally black and white. The goal here is to make trials more efficient while at the same time preserving issues that still have a gray area that need to properly get adjudicated at trial. I've talked about this before on this channel, but when we're talking about the procedure of litigation, there are multiple opportunities for a case to be decided or even dismissed entirely. The first one is the motion to dismiss, where the defendant basically argues that there is no legal way for the plaintiff to succeed in the lawsuit. At that point, you're not arguing from any sort of facts or evidence. It's just whether the plaintiff has stated a claim that can properly be adjudicated by the court. It's all entirely legal argument. And at that point, it's a pretty low hurdle for the plaintiff to clear, so long as the complaint is just properly drafted in a sufficient way. But cases do get dismissed at that stage from time to time. Now, assuming that the plaintiff's case survives a motion to dismiss, the next opportunity for the defendant to dismiss the case is a motion for summary judgment, the kind of motion that we're talking about in this video. This happens after the discovery phase, the period of time where both sides are exchanging information, they're taking depositions of witnesses, they're demanding documents. You get the picture. And a motion for summary judgment is where you basically look at all of the evidence that's been exchanged by the parties. And as a defendant, you say, taking all of the facts that exist here, there is no way that the plaintiff can win because there's no material fact that is disputed here. In other words, looking back at the elements of this claim, because every claim has a number of elements that they have to meet in order for the plaintiff to win, the facts that apply to each element point unambiguously to us winning. Please dismiss. But now when it comes to a motion for summary judgment, the plaintiff can also file an MSJ. And basically there they say, Your Honor, looking at all of the evidence that exists in this case, the facts so clearly point to us winning that we shouldn't even let this go to trial. You should just adjudicate this now and give us a win on this issue. Now, I want to be as clear as possible here. For either side to win on a motion for summary judgment, there can't be any element with evidence that can be interpreted in multiple ways. It has to clearly and unambiguously point to one side or another. Any amount of gray area means that that is something that is properly left to trial. So any claims that require intent, for example, are generally not going to win on any kind of a motion for summary judgment because it usually takes a lot of nuance and interpretation at trial for a jury or a judge to decide whether someone intended something. Of course, there are exceptions to even that because you could have one party just completely admit in discovery that they intended something. Crazier things have happened in litigation. But anyway, with all of that said, both sides did file a motion for summary judgment here. But what I'm focusing on in this video is the Attorney General's MSJ because that's the one that people seem to be really talking about here. In the AG's motion for summary judgment, she just went for the first cause of action. And importantly, this cause of action alleges that the defendants engaged in fraud. But in order to win under this particular law, the plaintiff doesn't have to prove any kind of intent or materiality. Let me take this straight from the court's order. Here the judge says, Executive Law Section 6312 authorizes the Attorney General to bring a special proceeding against any person or business that engages in repeated or persistent fraudulent or illegal conduct while broadly construing the definition of fraud so as to include acts characterized as dishonest or misleading and eliminating the necessity for proof of an intent to defraud. To boil it down a little more simply, the Attorney General has to prove two things. First, defendants submitted statements to banks or insurance companies that were false and misleading, and the defendants submitted these false and misleading documents repeatedly or persistently to transact business. So basically, for the first element, what we're looking for here is documents that don't match up between what the Trump organization had on the value of the business and what they were giving to the banks and insurance companies. And then for the second element, we are looking for a pattern of behavior that they're doing that multiple times with multiple financial or insurance institutions. And here, the judge found this multiple times over. For example, I already mentioned the Seven Springs estate, but the judge also looked at the Trump valuation of the properties at Mar-a-Lago, Trump Park Avenue, 40 Wall Street, and more. And with each one, the judge basically found that the documents talking about the value of these properties didn't match up with how the Trump organization was representing the business value to these banks and insurance companies. So that's why the judge decided that not only were there misrepresentations to meet the first element of this claim, but there also appeared to be a pattern of this behavior across multiple properties and with different business transactions for each property. So all of that together basically means that the judge decided that based on the evidence and the elements required for this first cause of action, he could reliably make that decision ahead of trial. And that led to the conclusion that the defendants were liable for fraud under this specific New York law. So what does this mean moving forward? Well, there's still trials scheduled for October 2nd, but Trump's legal team is trying to get that pushed back in light of this recent ruling. And at the same time, they have said that they plan to appeal this decision, which is not a surprise to anyone, I think. So with that appeal, this decision could get tied up potentially for years. But assuming that this decision does in fact stand, what this actually means practically is the cancellation of Trump's businesses in the state of New York. This seems like a really harsh conclusion, and in fact, it is. But the judge said that at the very beginning of all of this litigation, he determined that the attorney general had provided enough of a case to appoint someone as an independent monitor of the businesses. The person that the judge appointed as that independent monitor was retired Judge Barbara S. Jones. And what the independent monitor basically does is independently oversees the businesses in question to make sure that they're not doing anything illegal and that they're giving all of the information that they're supposed to be giving to show that they're doing everything above board. Basically, this is someone who is acting like a referee for this specific process. But on August 3rd, 2023, Judge Jones reported back to Judge Engeron that defendants had been giving incomplete information regarding debts to certain lenders, and they've been inconsistent in giving all required annual and quarterly certifications attesting to the accuracy of certain financial statements. Looking at this straight, she's telling the judge that the defendants aren't doing what they're supposed to be doing to show that they're operating above board. And the problem with that is usually when the judge feels it's necessary to appoint someone independent to manage a part of the litigation, usually that means that one, maybe both, maybe just one of the parties is in some hot water. And in a situation like this, that would mean that the defendants are the ones in hot water here. And if you show under that framework that you are seemingly not making efforts to work with the independently appointed manager, it's just going to end up biting you in the ass. And that's basically what happened here. And let me tell you, after reading this order, overall, I would say that the judge's tone throughout the entire thing was pretty spicy. At the outset, he's really not happy with the Trump legal team for what he says is essentially repeating the exact same arguments that they were making in previous motions. Like they filed a motion to dismiss, made all the same arguments as before, and they lost on those arguments. And he says that they haven't added anything new to these arguments, which basically means that they're just doing the same thing, trying to get a different result, which courts will look at as essentially vexatious. In other words, basically wasting everyone's time and effort and money, including the court's resources. And when courts think that you are actively wasting their resources, especially after they've previously warned, which he says in this order that he previously warned Trump's legal team not to do this, they're going to get really upset. And so one of the things that the judge did in this order is he looked at all of the lawyers on Trump's legal team that are named in the filing and gave each one of them a sanction of $7,500. So this is someone who clearly has had it up to here with Trump's legal team.
These go to 11.
And so on the subject of the independent monitor, the judge says that because the defendants are essentially not playing ball with her in the way that they're supposed to be, he feels it's entirely appropriate, considering the liability determination in this case. He says it's entirely appropriate to cancel all of the business certificates that are filed in New York. So yeah, dissolution of Trump's businesses in New York, and the judge has ordered the parties to recommend up to 3 potential independent receivers to figure out where the assets will go, similar to how a bankruptcy would work. Now, does this mean the dissolution of Trump's business empire as a whole? Probably not. This is a New York court with jurisdiction over New York businesses. The immediate effect of this order is not going to be to dissolve all of Trump's businesses everywhere. It's probably going to be up to other states where Trump does business and has different certificates that are filed to decide if they want to pursue something like this on their own. That said, I don't really know how much of Trump's business continues to center in the state of New York. I know he's been a fixture there for decades, and of course, New York is the financial capital of America. So I would imagine that a significant portion of his business probably is there, in which case this would be a significant blow to the operation of his businesses. But those are my thoughts. What do you think about this whole thing? It definitely is a stunning result, but do you think that this is too much power that's being wielded by the judicial system, or a proper method to keep powerful corporations in check? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more legal commentary and legal explanations like this, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you in the next one.